Welcome, everyone. This is the podcast Diritto al Digitale. I'm Giulio Coraggio, the location head of the Italian Intellectual Property and Technology Department at the law firm DLA Piper. Today, we have a great guest because Laura Caroli is one of the main negotiators of the AI Act. So welcome, Laura, and we really expect some very interesting insights from you during this chat.
Wow, thank you so much. A lot of expectations.
So, Laura, the first question is obviously how the negotiations went. I mean, between the first draft of the UAI Act and the approved finalized version, it's a kind of new word.
Absolutely.
So, what if you had to pinpoint the areas that led to the most intense negotiations, what would you name?
Okay, I would name actually three. Indeed, there were major discussions on several points, first within Parliament and then in trilogue. So that's why it took us a long time, even though we are even accused by many of having been too rushed in looking for any compromise possible. But I would name three. The first one, that was the first big obstacle that took us a long time to discuss, was Article 6, the classification of high-risk AI systems, because, as you know, in Parliament there was, let's say, an agreement, more or less, to among the groups some groups agreed to give up more on a few things in exchange of others, of course, as politics go.
Yeah.
So the agreement entailed that on Article 6, let's say we went a bit more liberal and decided that indeed within all the use cases listed in Annex 3, not all of them are necessarily all high risk, because there are very simple tasks that AI systems can perform that do not necessarily entail for them to become high risk and thus be covered by the AI Act. So we did understand that. So we try to find a way to accommodate this thinking in a way that would still ensure a good level of traceability for the authorities, you know, so that nobody could circumvent the law by claiming they were not high risk, you know. So so we introduced this filter, this famous filter in Annex in Article 6, saying that if the AI system in question, even though used in one of the use cases in Annex 3, was not likely to significantly affect fundamental rights and health and safety, of course, then it would not necessarily be considered high risk, but still it should be notified to the authorities so that they would have the overall picture of what was on the market. So, of course, after several discussions, redraftings, discussions, reflections with Council and the Member States, with the legal service, because, of course, there was at some point an opinion from the legal service that considered our version not exactly providing legal certainty, because it would give too much power to the providers to decide whether or not their system is high risk. In the end, since the Council too had a kind of a filter in their own position in the general approach, compared to the first Commission proposal that was if A, then B. So if you are in Annex 3, then you are high risk, no matter. This would have been the clearest in legal terms, the clearest solution. But since they drafted the Annex in quite broad terms, this could have included too many systems. And that was our concern that we tried to address. Parliament with this filter, Council with its own version of a kind of a filter that entailed, in any case, an intervention by the Commission with implementing acts in the future. So it wasn't clear even to us how this would play out. In the end, we went back to the drawing table. We took a lot of time. Really, the Commission did a good job there to listen to everybody and to craft, something that could go in that direction without being too vague. Still, it's not a perfect solution, I think. We will see how it plays out in practice. But this fact of introducing 4 specific conditions under which a system, even though listed in Annex 3, is not considered high risk, that gives a bit more of, that clarifies a bit more the boundaries that a provider has to move within in deciding whether or not the system is a risk. And then linked to this, the whole system of enforcement in case of misclassification, that is still very strong. The registration in the database, even in a specific section for non-high risk AI systems. I mean, so we really worked a lot on those 4 conditions, on the wording, to really make sure it was airtight as possible. And we see that actually, even as we speak now, some AI bills that have been approved, even in the US, actually take these same conditions as one of the triggers, to be considered high risk for an AI system. So we do think that we opened at least the way to a discussion there as to, how strict we want to be and how fair we want to be towards providers, because again, high risk doesn't mean dangerous. We don't want to punish anyone. We just want to make sure that the systems are safe to use and they don't pose any risks.
It's kind of interesting because the day after the approval of the UAI Act, speaking to our US colleagues, it was kind of funny because they were so upset, saying that their clients were extremely upset. That would have had a massive negative impact on the European economy, and their clients were considering to exit the European market and so on. But then I know that you don't like the parallel with the GDPR, but it is the fact of what's going on now.
Well, you mean that the fact that they are taking our same, yeah. No, but listen, I remember even last year I participated to CES in Las Vegas. It was super interesting because a lot of, I presented the European approach, what we were doing. It was before the trilogues even started, so it was actually 2 years ago now. Wow, time goes by really fast. So a journalist came to me and said, listen, we are super worried because I also do some work, represent some AI providers that work with educational tools, for day-to-day learning, so we are, our partners are really concerned that they will become high risk. And I said, but why? They will not become high risk if you really read the letter of the regulation. This is not what we intended to do. They don't make any decisions. It's everyday tools that you use in the classroom or whatever. I don't think they would ever fall within the high risk realm, because they are not close to a decision that impacts a person's life, even if you read it. So I think a lot of the concerns are a bit overinflated, I mean, yeah.
And, but so speaking instead about what companies, in your view, should be more concerned. So what provision of the AI Act is going to become more burdensome from your perspective?
No, but wait.
Companies comply with.
Wait, because I haven't answered the whole of your question. So I said 3 things, and I only named one so far. Maybe
yeah, otherwise we run out of time.
I'm sorry. No, but of course I would name general purpose AI models, the whole chapter that was negotiated a bit, maybe in a rush, but again, it was very intense when we changed a lot of time. It's the whole approach. So that's something that changed a lot during the negotiations. And then the part on prohibitions, of course, I needed to name this because it was always dear to our heart, as socialists. So, okay, if you don't want to go deeper into those,
on the general purpose AI, Laura, one point that was heavily negotiated was how to allocate responsibilities between deployers and providers, because at the end there was a massive shift between towards providers. However, deployers need to make sure that providers do their job.
But what do you mean now exactly? Because you mean responsibilities along the value chain, but it's also about the whole chapter of GPAI models is about introducing responsibilities for upstream providers to enable downstream providers, so still providers of AI systems, to better comply with the obligations and requirements they would have to comply with if they become high risk when they place their system on the market.
Absolutely, but there are, for instance, some cases where the deployer can be requalified as a provider, like, for instance, if they brand the GPA with their own logos, or they customize too much the product to their own offerings, or, for instance, the product can be trained on their own data. And even whenever they take off the shelf the product, they cannot just use those provisions as a sort of liability waiver saying it's not on me, right?
Yes, but I think it's good that we started this conversation because using, these tools like ChatGPT has become so easy and accessible to everyone that it's so easy to fine-tune a model and make your own application for whatever use you want to have. But if you use a chatbot like ChatGPT to write a judicial ruling, a court ruling, for example, as was the case in South America, then you should take some responsibility for it, because I mean, there is debate over whether or not that deployer would become a provider. To me, yes, it's exactly how you say. You are fine-tuning in a way a model to make it become your own product and to do something that is high risk, that is considered high risk. So at the very least, you become a high risk deployer, but at the very worst, you become an AI provider, a high risk AI provider. I think there would be some interpretation work going on that, but even I think in the Italian law proposal that is being discussed, that, by the way, I can give you my honest opinion on it, but it was clarified that you cannot use a model or a very easily accessible application such as ChatGPT for a high risk use case. Otherwise, I mean, it's too dangerous, So
what is your
clarifies a bit.
Italian the Italian AI Act? It's not called like that, but we know what.
I mean, the Italian action on AI was a bit interesting, because So we see during the negotiations, we see Italy joining Germany and France in signing the non-paper on pro-innovation, you know, on against regulation of models. Okay, we get it, but a few weeks later, it becomes clear that they are even split within the government in two. So between the two responsible figures for AI, one completely in favor of signing this non-paper, the other with a completely the opposite view. And this became very clear. There are articles about it, and they even at some point denied signing that non-paper. So I mean, we start like that, with that in mind. When we approved the AI Act in plenary after the Coreper vote, so in March, the Italian government had this great idea of organizing that same day this famous AI Day, very big event, Italian style, in which they didn't mention the AI Act at all, the day that it was being approved in plenary. So it was a big day for it, but whatever. And then they promised this 1 billion, whereas they didn't even unblock the 150 millions for startups that they promised like the year before. So I don't know if this billion will ever come to light. And then they propose, moreover, this, in the words of Butti, this pioneer, Italy becomes a pioneer in AI legislation. Okay, great. We are doing now the corrigendum of the AI Act as we speak, and you are saying you're the pioneer. And plus, when you look at it, it's basically the articles are a patchwork of what they thought could be added, you know, which agency to designate, something on innovation, something on skills, something on criminal law. It's really a puzzle, something on copyright, a bit here and there, you know, just to say we are here, we're we are making a law.
We'll see what will happen. Laura, last question. Everyone is kind of puzzled, as you said, about what's going to happen. We have the deadline of the 2nd of February when the rules on banned AI solutions will come into place, even though then the provisions on sanctions will not come into place at that time. But it's a kind of interesting scenario. So what do we need to expect in this in these 6 to 12 months?
6 to 12 months. So, of course, there is a lot of implementation work going on already. There will be some guidelines coming up. And, of course, we insisted that the Commission and the member states were even stronger than us in advocating for those, that the Commission publishes guidelines to help companies comply, navigate the AI Act, because it's being horizontal, it applies to so many areas of the economy and society that it cannot apply exactly the same way for everybody. So, of course, one of the first guidelines that need to come up would be the ones on prohibitions, because the way they are written can maybe raise a few questions. The final text is, of course, the result of a compromise that it is actually the result of that very long last trialogue that we somehow survived until the very end, you know, of that Friday night, still changing a word here and there. So, yeah, of course, it will be necessary to interpret a bit the provisions. On the fines, yeah, okay, you are right, but still many practices that are mentioned there that can be performed by private companies should already be forbidden or more or less forbidden by either GDPR or unfair commercial practices the Unfair Commercial Practices Directive. The other ones are about law enforcement. And we make it very clear that in those cases, law enforcement authorities using AI tools, especially when they are forbidden within the exceptions, should be supervised by an independent authority that is either the one designated by the law enforcement directive or another one that is designated under the same conditions of the law enforcement directive. This actually is something that the Italian government doesn't seem to understand yet. Maybe they haven't read it very well, because they are super sure that with their two agencies that they designated that are not independent at all, as we know, they would be free to do everything, but it's not the case. At least for law enforcement, no, we don't joke with that.
Well, there were so many disputes about it on the press between authorities, because you're right that even the privacy authority advocated its role as independent authority that would be better placed to enforce the AI Act. We'll see what's going to happen. The draft Italian AI Act is still a draft. So, and
let's see.
Time lapse so far. So, Laura,
can I add one thing?
Absolutely.
That, in my opinion, it's a bit of a provocation. That the DPAs, you know, they are very interested in being the ones enforcing the AI Act. I don't necessarily agree with that, because, of course, it's a great proposal because they are independent, and independence is key for this kind of enforcement. But they need to have also the technical competencies, because the very big cultural shift that needs to happen is the one between the GDPR framework and the product safety framework. So DPAs are not equipped to be market surveillance authorities. If they could merge a bit their competencies with some people from the market surveillance authorities, that would be actually the best outcome for me. But
I totally agree. At the same time, I find easier that the data protection authorities hire some additional engineers rather than having potentially inconsistent provisions on the same technology by two different authorities. While if it's the same authority, probably the risk is lower.
But absolutely, I'm just saying they have to mix it up a bit with their competences, you know, being open to new talents that know how to test a product, because it's not about checking internal practices in a company. It's about testing an AI system itself. Of course, there are some provisions that extend to the whole company processes, but like the quality management system, for example. But still, it's the system itself that has to be compliant, you know.
Laura, it was a very nice chat. Thanks for sharing the insights of these long negotiations. I still remember the day, the long nights, not night, with the Red Bull cans in the bin. There were
exactly. I posted that
in the pictures. So that there was transferring the situation of those hours. But I'm sure that in the coming years we will discuss about the AI Act as an advancement in our technological evolution. People say that Europeans are good at regulating and the Americans are good at innovating. I don't fully agree, because we need to create a more balanced regulatory environment where companies can better compete. And that was done through your work and the work of all the people at the European Union. So thanks for that.
Thank you for the kind words, and I hope so, of course. But let me tell you one more interesting anecdote from my trip to Vegas a couple of years ago. I came, as the little European who has to excuse herself for regulating everything. Sorry guys.
We are in
we
trouble.
don't want to. Yeah, exactly. And they told me, big companies, trade associations, etc. They told me, no, but are you kidding us? You are great. You are doing great because you have one key advantage compared to us, which is you regulate once for 27 member states. Whereas in the US, it would likely be a patchwork of very different state level bills as we are seeing right now. And each one will be slightly different from the other. So the companies will need to adapt according to where they place the system on the market. So in the end, you did better than us. And I agree with you that innovation can also happen, when you place boundaries, so which obstacles you have to overcome. And innovation is about also solving a problem, so when you have the problem of an obstacle, you find a new way that makes it compliant. Even GDPR created a whole new market for GDPR compliant tools. So